Today's topic will be regarding whether or not the death penalty be continued as a form of punishment in the criminal justice system. Currently, the death penalty can only be imposed on defendants convicted of capital offenses such as the killing of a president, treason, genocide, or other high-ranking officials, government officials rather, which would include a Supreme Court justice as well. A matter of fact, the other considerations include the realistic time frame it takes an inmate to go through the process leading and up to the date of execution, which is usually 16 to 18 years. This is based on the number of appeals that are granted to the inmate by law and the determination of the defense attorneys to move the case through the courts. Also, the examination to determine if it is necessary or appropriate has been researched and argued for many, many decades. According to Badu and Casil, they present an exhaustive debate on the topic, which only further emphasizes the complexity of the subject. They argued each side with judges and attorneys of whom each provided a list of items why it should be or not be an appropriate form of punishment for use in specific events or not at all. Additionally, in examining the complexity of the topic, we find that there are actually two distinct parts to the death penalty. The two considerations are, is it cruel and unusual? Also, is it too broad and subjective as a consideration? For example, it appears that its use and definition is arbitrary and left for the jury to decide. There are, it is true, some absolutes. For example, such as a person under 18 cannot be given the death penalty, but one who is 18 and a half can be. If the subject is 17 and 3/4, when arrested and appears in court at slightly over 18, does that change the legal scenario? It only adds to the complexity of the issue. It was in 1793 in Pennsylvania that murder was divided into first and second degree murder. On the other hand, only first degree would be eligible for the death penalty, which required additional fees as well. Most recently, the current explanation is no longer sufficient for that person to receive the death penalty. In fact, the Supreme Court in 1987 ruled that the death penalty can never be mandatory. This was the case of striking down the Nevada statute. Subsequently, all death penalty cases include a broad range of exceptions which still remain till this day. On the other hand, the other side of the argument is for what is or is not cruel and unusual. Therefore, the policy currently on one consideration is arbitrary, with so many alternatives, and the other consideration is of the manner of the execution. You must have both to successfully execute an individual. All of these considerations impact the courts in a significant way, and also the entire justice system as well, which also includes families, neighborhoods, and throughout the entire country. Because of the attention that the death penalty receives and the broad spectrum of excellent points addressed for each consideration, there should be a national forum to universally construct a strict and narrow interpretation of when to use the death penalty and how it should be performed. Additionally, another possibility is to have a national vote on choice during a national election year, which would be very imperative. Obviously, the death penalty remains a complex issue till this day.